SJC-11924, Commonwealth v. Brandon E. Mattier, and SJC-11960, Commonwealth v. Dominique Grice.
Good morning, Ms. Jacobstein.
Good morning, Your Honor. Rebecca Jacobstein for Brandon Mattier. Your Honors, this is not an identity fraud case. This is an attempted larceny by false pretenses case. And the reason it is not an identity fraud case is because Mr. Mattier did not pose as anybody else, nor did he attempt to obtain anything of value while posing as
He submitted
somebody
letters
else.
under someone else's name for the purposes of obtaining money, right?
That's what he did. That is an attempted larceny by false pretenses. And the reason that that letter, the presentation of the letter, which was a forged letter, is not posing is because posing is falsely representing yourself as another person,
Directly or indirectly?
directly or indirectly.
What does indirectly mean if it wouldn't cover this?
Well, I think indirectly would mean, without explicitly saying it, but inferring it by the circumstances. If you accepted a package, at a residence and somehow kind of implied that you were the person who the package was for, that kind of thing. This isn't that. This is, when you falsely represent yourself as another, you're basically assuming the identity of that person, and at no point did he do that. He just said, this is a valid and accurate letter, when it in fact was not.
He would have had to call and say, I'm sending you a letter, I'm Dr. X, and you're going to get a letter from me.
That would be posing. Or if he had signed it in front of a notary, as if he had been Dr. Burke, that would have been posing. But this wasn't posing. This was just the submission of a forged document. And if these circumstances...
Hold on. If it's, I see. Then the posing would be before the notary, but it's still going to the same place, right?
The letter's still going to the same place.
Yeah.
Right, it's not the submission of the
In
letter.
that example, you would say the posing happened before the submission to one fund.
Right, that's what I would say. I said that thank you.
Could you help me before you get too far in? What's at stake for the defendant in this case? I mean, he got a concurrent sentence with the attempted larceny, which I don't see that there's any substantive challenge to that case.
No, Your Honor,
You need this, don't you, in order to be able to make a motion to suppress argument?
that's what I need. I need this because, because he shouldn't have an identity fraud on his record that he didn't commit. This is our justice system, and you should only be convicted of crimes you did.
Should be a forgery conviction. Is that
Well,
what you're saying? It should be a forgery
it doesn't actually
conviction.
meet the forgery statute, but yes, this would be...
Oh, it doesn't? It's not a
I
forgery?
think for forgeries, it has to be a specific kind of document. I don't think just a letter would
It's
count.
not just a forgery. This is something different.
What this is an attempted larceny
Posing
by...
as someone else in order to get money for a third person.
Well, but
Posing, I'm sending you a letter in which I am representing that I am the doctor.
But he didn't do that. I am sending you a letter where I am representing that some other guy, the doctor over there, signed.
But
That's the difference.
I signed it, and I'm representing myself as the doctor.
Well, but that's not what he's representing. He's not representing that he signed it. He may have signed it.
He's representing that the doctor signed it when the doctor did not sign it.
That is correct, and that is the false representation. It is not that he is the doctor. Those are different representations.
But it's not an identity fraud. It's a false representation.
It's the false use of someone else's identity. He's using someone else's identity to submit this letter. Isn't he?
Well, he is submitting a letter under somebody else's name,
Right.
and in support of his application.
Profession and letterhead. So it's not just using a random name somewhere.
No, he didn't make up a name.
Right. Okay.
But what this does is if this is an identity fraud, then all forged check cases become identity frauds, and I don't think that that's really the purpose of the statute. The purpose of
Couldn't the legislature have made the same act a crime under two different statutes?
Yes, absolutely they could, but I don't think that's what they did because this has a posing, and one of the things you're doing is you're using the personal identification, which is personal identifying information, which is information that allows you to assume the identity of the other person. So it's really, and this goes into my second argument, which is he didn't do it while posing.
Where is the simultaneity argument based in the language of the statute? It rests on the word "and," right?
Well, it's twofold. It rests on the word "and," but it also rests on the fact that the personal identifying information is defined as that which can be used to assume the identity of another. So by using the personal identifying information, you are assuming the identity of the other person.
Is that right? Can't you use it without assuming the identity?
No, you can't because you have to pose.
So it's kind of circular, isn't it?
It sounds a little circular the
Does.
way I say it, but the way I think about it is that what they're trying to prevent here is you pretending you're someone else and then getting someone because they think you're that person. And that's not what happened here. He didn't get he didn't try to get this check because anyone thought he was Dr. Burke. At no point in time did anyone think he was that, nor did he want anyone to think he was Dr. Burke. He got it because they thought that this aunt was a double amputee based on a false representation he made that this letter was accurate. It's not the fact that he is in any way Dr. Burke.
Well, but he needs Dr. Burke.
He needs to
He
make that
couldn't have
false
si-
representation.
He couldn't have signed that letter himself.
Dr. Burke?
No, Mr.
Oh,
Mattier.
well, right, of course. He does, but it's not the fact that he made a false representation. It's the nature of the false representation that makes it identity fraud. And the nature of the false representation has to be, I am him. And that is not what his false representation was.
So if I were to write a letter saying, I hereby grant Justice Duffley authority to withdraw $10,000 from my account, signed Chief Justice Ralph Gantz, and then Justice Duffley went to the bank and used it, that would not be identity fraud.
So you posed
Well,
as
I
Justice
signed a
Gantz.
letter as Justice Gantz,
Yes,
a
so
real
you
person.
posed that.
I didn't go to anybody and have it notarized or anything. I just signed a letter. Justice Duffley then took it to the bank and said, I'd like to withdraw $10,000 from Justice Gantz's account.
Right. What I'm saying is that Justice Duffley has just
Stole some
committed
money.
as just if it gets cashed, as it has committed larceny by false pretenses.
But I haven't committed identity fraud by basically signing his name to a letter authorizing her to take money.
Right.
What has Justice Cordy committed any crime at all?
Joint venture with
Conspiracy
me.
to commit larceny.
Before I let you go, let's assume you prevail on the identity fraud. What do you do about the search warrant, which has a provision that says you can search 133 Northampton Street, Apartment 402, and you can search the person in the possession of Brandon Mattier?
At the above location.
Yeah,
Wasn't he
was
right in
just
front of it?
outside, isn't he?
So he was outside, and that's my argument, is that the search warrant covers the curtilage. That's what the search warrant covers. You can search the dwelling and its curtilage. That's how far it extends. And in a multi-unit apartment building such as this one, that is a very limited concept. It only covers the apartment, and then if there were private areas under their exclusive control within that. But he was on a public sidewalk in front of the apartment building, and at that point,
So we've decided that curtilage is the limits, even though the warrant mentions him in particular and his person?
well, but it says his person at the above location, so the question is what the location is.
So he's got to be at, in the sense that within the curtilage as opposed to just outside the curtilage?
Yes, because it didn't limit it to wherever he was. It said at this location.
Well, he is at the location.
Well, the location is really only the apartment. I mean, because, especially in an apartment building, you can't just be getting anyone who's there. There's lots of people who go in and out.
Let me ask you a slightly different question. you join, even though you don't brief it, you join in the issue about the jury voir dire. But you had 5 peremptories also and didn't exercise all 5 of them.
That is correct, Your Honor.
So how do you get the benefit?
Well, I think at this point, the writing was on the wall. I mean,
But you could have excused those jurors.
you could have excused them, but more people would be coming with the same problem. And so at this point, how does,
Yes, but how can you make the argument if you haven't exhausted your peremptories?
because at this point, because there were so many people that had one fund connections,
Bought a T-shirt or something.
and
A lot of us bought T-shirts.
a lot of people donated, just a little.
ATM use.
Yeah, I mean, you know, it's very limited, the number of people who weren't there or.
So did the
but-
judge in any way poll the veneer to make sure that he knew in advance how many people were falling into that category?
Didn't he ask individual questions?
Everybody was individually questioned, so they
Okay.
wouldn't know until they got up there. So they wouldn't know if that next person coming down the pike was going to have the
I
same
see.
problem and then just even be worse than
So he didn't ask general questions of the veneer?
I don't think he did, but my co-counsel might know better.
Okay.
Unless there are any further questions, I rest on my brief. Thank you.
Thank you.
Good morning, may it please the court. My name is William Smith, and I represent Mr. Grice. It's my privilege to represent him. I would like to speak about that same issue, if I could, the jury selection issue. I would suggest Judge Locke said it best sort of at the end during sentencing when he said that the victims in this case were the people who donated. So, of course, the problem being in my client's case, Justice Lank, to sort of segue into what you had raised, the peremptories were all used, all 5 of them.
Your clients were?
In my client's case, correct. His trial counsel had exhausted all of his peremptories, and then 2 of these jurors were put on to the jury. So, but it's actually not just that. I mean, the way I look at this is the primary concern is that the people who had donated evinced, sort of a bias going into this. I mean, not to their fault, but they chose to donate to the one fund.
Was other inquiry made of jurors as to whether or not because you could say that the entire city was victimized by the marathon bombing, and that there are many people who felt strongly whether they donated or they didn't donate. Were
Correct.
questions put to the jury members as to whether or not they were in the city or were affected in any way by the...
I was thinking of that just a minute ago. My recollection is, as co-counsel, which was that the judge individually questioned.
So the judge made a determination as to each juror whether or not they were...
Correct. Once it was raised as a threshold issue.
Is there any difference between the individual juror who buys a T-shirt or makes a $25 donation and the big corporate donor, the Bain Capital that you had in this case? I mean, why shouldn't those be treated differently?
I was puzzled by that, frankly. The judge sua sponte in this case, in fact, removed a juror for that very reason, Your Honor, because that juror had worked at Bain Capital. Bain Capital gave, I think it was at least $1 million to it. And the way I look at it is, in fact, that's far more attenuated than a juror who is directly giving, $20, $50, $1,000, or whatever the case may be. I mean, that's a donation. They're making that choice. But that same juror, in the case of working at Bain Capital, he's not making that choice. He works at Bain Capital. The people, the executives or the board of directors, whoever is making that choice for him. So it's far more attenuated than the juror who elects to give, not to their fault. Obviously, I'm not here to say that anybody should have been faulted for giving to the one fund. But it was also raised at the trial, when this discourse was sort of going back and forth, so many people have given to this one fund, and so how can we really find jurors? But the fact of the matter is, in this veneer, there were plenty of people who had not given.
So did the judge conduct a general questioning at all, or was it always just an individual, so that you had no way of knowing ahead of time whether or not somebody was a donor?
Correct, Your Honor. My recollection is that was not done. There was no sort of general questioning beforehand. I could be wrong on that, but that's my recollection. But it was certainly raised throughout the entire process. So the problem is that,
So what is the standard? It, I assume, is abuse of discretion, is the claim.
correct, well, the case law speaks both of abuse of discretion and also legal error.
Well, which is it? I mean,
Well,
it's
I would
not-
argue it is legal error. It is legal error, Your Honor.
As a matter of law, whenever anybody contributes to any charity which is not defrauded, but which is attempted to be defrauded, that the judge has an obligation to remove that person?
It could be the case, but the fact of the matter is, I would suggest that in any event, it is within that line of cases here. We are within that line of cases. It speaks of presumptive bias, Your Honor.
But
And-
it's presumptive. Doesn't it mean that the judge can question and the presumption can be overcome?
Well, in a case like this, what the case law tells us is in a case like this where there is such a close nexus between what happened, that is to say, the act of the juror donating to the charity, to the one fund in this case, there's such a close nexus between that and what would be seen as the bias that yes, the judge would be compelled to remove the juror, is my argument. And as I was alluding to before, there were certainly plenty of people in the jury pool who could have, who did not donate to the one fund.
How do you know that? How do you know who did and who didn't?
Well, just go through the jury selection. It's a very good question, but through the jury selection process in this case, which seemed to be fairly lengthy, there were some people where it was not an issue. It was not in any way an issue. Out of this jury, I believe that there were 2 people who had donated, so many did not. So the judge had also raised the concern that sort of, and then the Commonwealth is arguing this same thing on appeal, saying, well, you could never have a jury in a case, let's say, hypothetically, a prosecution for unemployment compensation fraud. And you could never have a jury because, you know, people, taxpayers pay, or public fraud, I guess would be a better example, welfare fraud. Taxpayers pay into that fund, and that fund is rated. But again, it's entirely distinguishable because in that case, the taxpayers have no choice. So they gave beforehand, they have to pay their taxes. Whereas in a charity, the problem is it shows that that juror has that predisposed sympathy, bias, if you will, toward the charity. That's what distinguishes this case.
Did the judge ask these 2 jurors questions about whether or not they could remain free?
He did. For sure, he did. But again, to go back to Chief Justice Gantz's question, I would suggest that this takes it outside of that paradigm. If it was just a question of if this presumptive prejudice or sort of innate bias issue was not here, then you
But
just
it's not
have
really
this
presumptive at all.
Well, I would suggest it is.
But it's an absolute presumption.
Right, you're saying it's more than presumptive. You're saying even with inquiry, you can't do it.
I apologize. That's correct.
meant,
That's
yeah.
correct. And I apologize, but that's sort of my own parlance. But in any event, the case law certainly speaks of that innate bias being a grave concern, and I would suggest that's exactly what we have here.
Was there
And
any indication of how much money any of these people gave?
I don't think so.
T-shirt versus, you know,
Correct. I think they were, but I do think they were direct donations. I think one of these jurors, I believe, it was sort of a T-shirt type scenario. I guess under either scenario, they know when they're buying the T-shirt, they know that it's going to the one fund.
but the one fund, in fact, was not out any money in this case.
Correct, that's correct, but that's not my argument. My argument is not that these jurors lost out on money. My argument is that these jurors, by having given to the one fund, showed that this was a charity of choice. And then here they are sitting on my client's trial as jurors. And as Justice Locke said, the one fund, it wasn't just the one fund, you know, as an organization, as a corporation, whatever the case may be, that was victimized. Judge Locke said during sentencing, the victims were the donors. And those donors, 2 of those donors were on my client's jury. So that is what is most disconcerting about this case.
All right, thank you.
Thank you.
Randall Ravitz for the Commonwealth, and with me is Gina Masada, one of the trial prosecutors on the case. I'll start with the jury selection issue that was just addressed. and just see if I can answer some of the questions that were raised by the court. One is regarding the standard. This court has said more than once that the standard is one of great deference to trial judges, taking into account their ability to observe the jurors and assess their ability to be fair and impartial. And so the standard is described as one of clear error with respect to a finding of impartiality or clear abuse of discretion. Now, as far as what happened here, the judge started with a set of general questions to the group. And those questions didn't specifically ask about donating to the one fund, but they did ask things like, do you have a personal interest in the case? Have you formed an opinion about the case? Are you aware of any bias or prejudice? And then there were other things. But then as the judge called each juror up individually, he went through a series of questions about whether they or somebody they know, somebody close to them, had run in the marathon, whether they ran in 2013, whether they or anyone they know was injured, whether they were emotionally affected by that such that they couldn't be impartial, whether they gave to the one fund, whether if they did give to the one fund, in fact, if they answered affirmatively to any of these things, the judge would ask a series of follow-up questions. And basically, he would get to one point or another. Either he would get to a point where they would say they could be fair and impartial, or he would get to a point where they couldn't. If they said they couldn't be fair and impartial, they'd be excused.
What about the person, because I don't know this, the Capital One person?
Right, Bain Capital. It's surprising that would be raised by the defense, because that was an example of a judge doing exactly what you would want. The judge went through and asked a series of questions, and it came out that
Was this during individual voir dire?
This was right. That's correct. It came out that this person worked for Bain. Bain had given a lot of money. The guy said, I'm not sure. I might have given as part of a fundraising event. He said he could be impartial, but then the judge didn't say, I find this person to be impartial. He turned to the attorneys and said, do you have any objection? And one of the defense counsel said, well, actually, I do, because Bain Capital was such a big sponsor that their name is on a lot of the literature, and it could be the case that there are exhibits put before the jury that actually say the name of Bain Capital. And so then the judge said, all right, I'm going to inquire further. And he inquired further with the juror about that and then ultimately decided to excuse the juror himself. So that's a good example of just how thorough and careful the judge was here.
I take it, I'm just reading in the defendant's brief, the juror said, this is a really big deal for our company.
That's right.
It's a huge donation, a
That's
really
right.
big deal for our company.
That's
which
right.
is a little different than, yes, I bought a T-shirt, or yes, I made a contribution.
That's right. $1 million donation, big deal for the company. As far as some of the others, they were not necessarily asked, how much did you give? But it was common for people to reveal that in the course of their answer. So maybe in the course of revealing it, it would become clear that it was a nominal donation or something like buying a T-shirt. Regarding the two jurors who were led on, so one said that she had contributed. It wasn't revealed how much, but then she said she answered affirmatively to a question about whether she could put aside entirely the fact that she had donated and decide the case fairly and impartially based solely on the evidence and following the instructions on the law from the judge. The other person who was led on said, my brother, who's a resident of Washington State, is a volunteer firefighter, and we purchased T-shirts that the proceeds went to the one fund. And then the juror was asked whether it would affect her impartiality, and she said no. So these were, there's also, by the way, I should mention that that second juror, in the course of answering other questions, she offered up statements herself. I understand that these two were not involved in the bombing themselves. So, and these are two very different things. So in other words, whereas most jurors actually just answered yes or no to a lot of these types of questions about this distinction from the judge, here was a juror who actually offered this up, showing that she got it. So those were the two jurors who were led on.
Can we turn to the posing?
Yes. Okay. So the fact is that the defense is essentially reading things into the statute that are not there and that are not in the recitation of the elements.
But if posing is directly or indirectly using the information to present yourself as somebody else, right?
Right, that's right.
So when he sends into the one fund the letter which has the Dr. Burke's signature on it, but he's signing the letter, his own letter himself. So how is he, who has he posed to as Dr. Burke?
That's just it. I think part of the problem with the defense argument is that there's this notion that the person could only be posing as one person. It had to be one or the other. Here, he was basically posing as two people. One was as himself. That was the main application. I, Brandon Mattier, I'm requesting this money for myself. And supporting me, here I am, Dr. Burke, saying in the letter, speaking in first person about Dr. Burke and in third person about Brandon Mattier, saying, please contact me for more information about Dr. Burke, about this person who was released from our trauma center, and she was released to the custody of this other person, Brandon Mattier. So I would just liken it to this kind of situation. Imagine if somebody came into the One Fund offices and said, here, I'm Brandon Mattier, here's my application. And they said, you know, thank you, but your application is insufficient. We're going to need to have somebody, a doctor, talk to our medical staff. And Brandon Mattier says, okay, and then comes back the next day wearing a lab coat or whatever, goes over to the medical staff and says, I'm Dr. Burke, and I'm here to support the application that was submitted yesterday by this
But that's the one
gentleman.
thing he never did.
What?
But that's the one thing he didn't do.
He didn't
come
appear
in
in
and say,
person.
I'm Dr. Burke.
No, he did in the letter. He said, he referred to me, sincerely Dr. Burke. He referred to our trauma center, and he referred to his true self in the third person. So, you know, there's one way of looking at the defendant's argument is that they're saying if there's a disconnect between what is being said by the person who prepared the letter and what the letter says, then the problem is just with the letter. But why? Why can't the jury say, no, in preparing the letter, it's not just that the letter was fake, it's that he was faking when he prepared the letter. That's what he did. He basically endorsed himself while posing as Dr. Burke. And this statute,
the letter had some features about it too. It had the logo of
right. It had the doctor's name, his title, his signature. It had the hospital logo.
Is that when you say it had his name? Was it also in printed form up at the top of the letter, as if it were his personalized stationery?
It appeared to be the stationery of the Boston Medical Center with his signature and a printed name and title underneath the signature. And of course, it purported to be, it was clear that it was trying to sound doctorly. It was purporting to make a diagnosis. And the legislature, looking even just at the not just the way the order of the elements, because we'd say that what the defendants do is essentially reorder the terms of the statute in a way to change the elements. And then they add this wild concept.
But you still have to deal with the definition of pose.
Right.
Pose is to falsely represent oneself.
That's right.
As another person or persons.
That's right.
So did he falsely represent himself as Dr. Burke?
Yes, he did in writing. And
He didn't say I am Dr. Burke.
he said me. He said our trauma center, and he signed it sincerely, Dr. Burke.
But that was, I mean,
That's part of the letter.
that's part of the, that's
Well,
part
no,
of the forgery.
he was playing as Dr. Burke and writing the letter. That's what your argument is.
Yes.
He was playing as Dr.
Yes.
Burke.
It was the fact that he wrote it in the first person that makes a difference. I mean, if this were some other form that didn't involve the person speaking through the letter, it would not be posing. I'm just trying to, I can't think of anything right now that
Well, it would
that
be like a
doesn't-
transcript, and you want to
Yeah.
get a good job, so you
Yeah.
pretend that you got all A's instead of all B's, and so you get a fake transcript, and then you've got the registrar of Harvard University, wherever you went, and so now you're posing as a registrar who's saying that I got A's, but
Right. That's right.
I mean, it's a stretch.
Well, but if you look at the way the statute is written, it says directly or indirectly in the definition of posing. Then in the list of types of personal information that could be used, it's a long list, includes things like computer passwords. So in other words, the legislature was not just talking about a face-to-face impersonation, and it was...
That's pretty clear, but let me just go on. Isn't it what they were talking about is taking all these bits of information, whether it's a Social Security or whatever, so that you could then pretend to be the person who actually owns the Social Security and has the birth date to get credit, and then take fake credit cards and run them up to their limits. I mean, that's not what was really meant there, and not just now to turn all the other potential forgeries into also this?
Well, here's what we're saying. Yes, a person has to pose as somebody else, and they have to try and get something. But the thing is, there's nothing in the statute that says they have to try to get something in such a way that a payment is made to a third person, and then they're standing in the shoes of the third person.
So
The statute doesn't say that.
Every forged check is identity fraud?
If somebody signs somebody else's name and is thereby presenting themselves as that person, and the other elements are met, we would say it does qualify. But here you have even more than that. You don't even need to limit it to that, because you also have the content of the letter.
Well, I don't have more. I mean, either the statute covers this or it doesn't, right? I mean,
No, I mean,
cover this, I have to cover forged checks, don't I?
well, we would say that is covered by the statute, and that there's no reason to conclude that just because it could also be something else, like forgery or like larceny by false pretenses, that it couldn't also be this. This court in the Clark case looked to the press release put out by the legislature for evidence of the legislature's intent. Well, there it talked about things not just about taking somebody's credit, but also damage to somebody's reputation, subjecting them to criminal penalties possibly. So
Wasn't that all part of the taking someone's credit and destroying it, so that that actually is what, because you then have a lousy credit rating, you can't get a mortgage, I mean,
But that's one. Even if that's the paradigmatic example of identity fraud, the legislature didn't limit it to that. There's nothing in there, there's no additional element that would read, that would capture that concept. The legislature said posing and using another's identification to obtain something of value. And, getting back to this whole reputation concept, the fact is, this case is illustrative because you could envision a point in time when some people might have wondered if, in fact, Dr. Burke was in on this scheme. And he had to take time away from his medical practice to come in and testify and explain to people that, no, in fact, he wasn't part of this scheme. So when the legislature expressed concern about impersonation that can cause damage to somebody's reputation and maybe subject them to criminal sanctions, this is the type of harm that's encompassed within what the legislature was trying to prevent.
Rule of lenity play any role here?
I'm sorry?
The rule of lenity? I mean, in other words, it seems to me that your interpretation is hardly hits you between the eyes when you read the statutes. You've got to work to get there, I think.
The rule of lenity only applies if the language is unclear. And respectfully, we say the language isn't unclear. It says posing as another, there's the intent to defraud, but then posing as another person without the express authorization of that person, and uses such person's personal identifying information to obtain or to attempt to obtain
And
something
Judge
of value.
Locke thought it was a real stretch.
Well, it's just not, it's not the typical example, but it involves all the same harms.
Right, but I mean, as to Justice Spotsford's point, it's a stretch. And
Well-
if it's a stretch, doesn't the rule of lenity come in?
It's only if the statute is not clear. I mean, it does, it
That's the
fits.
point, isn't it?
Well, right, if you were to find that the statute is unclear, but that the elements are spelled out, this additional kind of element is nowhere said in there. It wasn't recognized by the appeals court. The appeals court spelled out the elements, and this fits within that. It's supported by consideration of the legislative
There's
intent.
never been a case quite like this either,
No.
where you've tried to prosecute somebody in this fashion.
No, but the fact that other cases.
Cases don't really contemplate this kind of a factual.
No, it's more that the few cases that there are didn't happen to involve this.
Right, so we don't really know whether the elements as stated were correctly stated for something like this.
You know, we think it's very clear from the text of the statute and from evidence of legislative intent within the statute, like directly or indirectly, and from external sources.
But
All
there's
of that.
not much in way of legislative history, right?
There's not much. But what there is has already been cited by this court as being instructive, and we turn to that same, those same sources.
Right, look at section D.
Yes.
Financial loss may include any costs incurred by such victim in correcting the credit history of such victim. Any cost incurred with any civil or administrative proceedings to satisfy any debt or other obligation. I mean, sure seems as if the legislature was focused on what we all understand to be identity fraud, which is the theft of somebody's identity. And
Well, the fact that they're providing for a remedy in those situations doesn't mean that they're foreclosing any other situations. The legislature could have used the word while, as it did in other false impersonation statutes. It could have,
What do you mean?
well, in other words, there statutes regarding giving a false information while doing something like driving. That would have been easy enough to capture. If they wanted to limit it to obtaining something of value that was intended for the person who's being impersonated, not for the defendant, they could have put that in. They didn't. And again, everything points in the direction of trying to craft a statute that's broad enough to deal with any of the types of harms that could arise, whether it's loss of credit or having to explain to people, no, I was not involved in this scheme to defraud the one fund. If there's nothing else, thank you, Your Honor.
I'm sorry, is identity fraud a misdemeanor? It appears to be. It doesn't appear to provide for state prison.
Correct.
So how does that get you past the concern? I had not focused on that before, but if the concern is that you cannot arrest somebody for a misdemeanor without a warrant, how does the identity fraud help you?
It contains its own
Right.
exception.
Oh, it provides, it gives you the power to arrest in that statute?
Yes.
Gotcha.
Can-
Okay.
Can I just one question? Is there in fact a Dr. Burke who works at?
Yes.
Okay.
Yes.
So he is a real person?
He's a real person. He came in and testified. Before he came in and testified, the hospital had contacted the One Fund and said that it was concerned about this fabrication. And that's part of how this came to our attention.
Okay, thank you.
Thank you.
Thank you.